Hey everybody, welcome to the Zoom at noon, Garden State CLE. It is now 12 o'clock on the East Coast for those of you who are watching around the country. And we're ready to get going with our CLE today, which deals with ethics instruction in New Jersey. And the question is really, does it work at all? I know so many of you and you're all such good friends and colleagues. What I was going to do is ask a number of you to participate today, and I'll be asking you questions as we go along. Nobody will be embarrassed, and I want to hear your honest opinion, because anything you have to share with me, I can pass on to the Supreme Court, who's very, very concerned about what we're going to be discussing today. And they want to kind of, make this ethics instruction serious and the best it can be. Okay, so here we go. Let's take it from the top, and I'm going to take a historical standpoint about this. We've been engaged in CLE instruction in New Jersey on a mandatory basis since 2010. And I just want to kind of give you a little bit of background on this. This comes out of a case that I was collaterally involved with. I'd love to show the video of it. It's really pretty amazing.
Court, please, Justices. First of all, I would like to begin by assuring this court and Justice Albin in particular that I'll never write a letter again to anybody that wears a black robe. Having said that, and I'm recognizing that, and I'm not being flip, but I'm saying that I recognize that I was out of bounds when I did that.
You realize you're a judge and not a jury.
I do understand.
You know the term, you're not the judge and the jury.
Nor did I try to be, Justice Albin. I never went in there to convince anybody or reprimand them. I go in there to explain and respond to questions they have.
Let me read to you one of the things you told that jury, and to which you have admitted. You told them that the defendant would have testified if he had been not guilty.
No. I told him that he would have
I'm reading to you from the complaint that you admitted. You admitted that you said that according to the complaint. And now, are you denying that?
Yes. What I did say was that the defendant would have testified had he not had criminal convictions. That was the reason I said. I didn't say that he was not guilty. But aside from that, I saw the PCR situation, and I was aghast. I was stunned. I was flabbergasted, because the PCR situation didn't work. And I had a position where I felt somebody should say something. And Justice Lavecchia baited me in her opinion and said it was outrageous, pejorative, inappropriate, and many of the things out of context could be considered that. I can't say that I agree with every characterization.
Your remarks to Harris weren't from the bench. They weren't slips of the tongue. You prepared a long written opinion. One of the issues that you were asked to decide was the constitutionality of the death penalty. And apparently within the first paragraph on that particular issue, you determined that there was no violation. And then you go on to speak about your personal opinion about the death penalty system in this state.
Yes, I did.
It had no relevance at all to the case. It was you on a soapbox with your robes on, speaking how you felt. Was it anything more than that?
I would like to think it was. I would like to think that it was.
How was it? It wasn't related to any issue that was in dispute. It was a political pronouncement by you in robes. And I don't know how you can even begin to justify that now.
Well, political announcements and pronouncements have been made by people in robes in this state, in this Supreme Court, in the lower courts of our state.
You don't get the opportunity when you're in robes to get on a soapbox and make political statements. You're there to decide a case. The issue was the constitutionality of the death penalty. You had nothing to say on that subject and then went off on this tirade.
That was one of the 5 objections raised at that time. One of
you
the 5
admit that those remarks are wrong now? Or are you attempting to justify them?
Well, this is the first time I've been confronted with whether I will admit the remarks were wrong. I was confronted with what I understood to be, naively or otherwise, I was confronted with a situation where I could say, bang, bang, Strickland, no application, what have you. I was confronted with that situation and felt obliged, rightly or wrongly. I felt not as a deviation from my the
You were
principle.
asking the legislature to
I said the
basically
legislature or the court.
repeal the death penalty. What gives you that right as a judge on a bench in robes?
I think the invitation was to the court or legislature in light of all of the circumstances to declare the death penalty a nullity. What gives me the right, I guess.
You weren't arguing on constitutional grounds. You were arguing on public policy. Like we should just take this up because we don't like the law, or because according to you it doesn't work. We should repeal it?
No, I think my invitation was to declare the death penalty process unconstitutional.
You never said that.
I believe well, if I didn't say it, I didn't say it clearly, but that was my intention. I invited, I said perhaps it's now time for the courts or the legislature to declare the process fundamentally unworkable and unconstitutional. Perhaps it was a failure of language, and there were certainly wretched excesses in the opinion, but the heart of the opinion and the direction of the opinion was, I believe, was valid, sincere, and a appropriate response given my judicial responsibilities.
You were calling to the citizens. I'm quoting you. One might hope instead that this state and its citizens would, if no more than as a consummately practical deduction, simply resolve to set aside the comfortable pieties of the argument, eliminate the death penalty of the game. ... Are you telling us a judge should be sitting on the bench and calling for what the citizens should do on matters that would be taken up in the ballot box?
That a dialectic should be developed between the court. I don't think we should hide necessarily.
You're asked to apply the law as a judge. It's not your business to ask for a law that you may disagree with to be repealed. It's just not within your province as a judge.
Then with
And
that
then that's part of
declaration,
understanding what your function is as a jurist.
Do you understand that?
Justice Azali, I'm not I know the easy answer would be yes, but I'm not sure that I do. And I have to think about that because what I had hoped to do would be to open an exchange. What I hoped to do was to bring, only I could do this. There wasn't anybody else who could do it. The prosecutor couldn't do it. The public defender couldn't do it. This court couldn't do it as a matter of course. There was a confusion that existed with the PCR, which was supposed to be the analog to the habeas corpus, which was dysfunctional. And I, mistakenly or not, according to the way Justice Alvin suggests I did things, I thought that was a responsible position to take.
In any event, you have acknowledged to us a few seconds ago that there were, quote, wretched excesses,
There were.
end quote, in the letter. So to that extent, and to the extent that you may have made mistakes, which you've just acknowledged, to some extent the letter was wrong.
Yes.
Do you agree to that?
I absolutely agree to that.
To what extent, we won't attempt to quantify.
I would quantify it on the basis of a reprimand.
No, I'm talking about how much of it was wretched.
I realize that, but I'm just making that comment.
It's really the oral argument in this case. Mathesius was a Superior Court judge, and he is really going to be. He decided he was going to make a statement. Well, let me just go back and tell you the whole story. He had a First Amendment issue. He made some statements and had an attorney representing him, a New Jersey attorney who is one of the masters of First Amendment law, especially First Amendment law related to judges. And the attorney went up and did a masterful brief and went and argued it before the Supreme Court. And I was sitting next to another Superior Court judge in the Supreme Court chambers watching the argument. And I thought to myself, hey, he may win this thing, meaning that maybe he'll get a censure or a reprimand out of this, And then the Chief Justice says those magic words, does your client have anything to say? All right. And knowing Bill Mathesius as I do, there was no way he was not going to say something to the court. So he went up and started making statements to the court, and they were waiting for him. Justice Alvin really was the lead justice going after him. And the whole thrust of what was going on is that the people in New Jersey depend upon judges to be above the fray and to decide cases based on law and evidence and nothing else. No politics, no religion, no nepotism, none of those things. Law and evidence. And if you stop to think about it all, this, I've raised this before the Supreme Court myself, this really goes to the heart of why we have ethics instruction for attorneys and for judges. Well, think about it for a second. A judge, even a municipal court judge, but especially a superior court judge, they have enormous power over individuals. You know, they can throw you in jail for 30 years, and they used to be able to order you to be killed. They still have that power when it comes to animals. You know, they can, in municipal court, they can still order animals to be destroyed. I mean, it's an enormous amount of power that we vest in our judges, okay? The problem is that the more people who become involved in a particular case and controversy, the less power the court has. Sure, they can exercise a lot of power over one person, two people, 3, 10, whatever it may be. But when you start getting into the area of having cases involving hundreds of people or thousands of people, or in the case of the entire state of New Jersey, 8 million people, there's no way for the courts to enforce their judgment and orders. They rely completely upon the public's acceptance of their judgments and orders, saying that we as the people will voluntarily comply with the judgments and orders of the court. Now, there's a social contract here that we have with our judiciary, and it is as follows. We, the members of the public, we will comply voluntarily with your judgments and orders, provided that we can be assured of 2 things. Thing number 1, the case will be decided on law and evidence and nothing else. No religion, politics, things of that nature, nepotism. And number 2, that we're going to our day in court. In other words, you will afford us the opportunity to say what we have to say and listen to our arguments. On the other hand, when people, especially when there's ethics issues involving judges and attorneys, every time there's some serious ethical violation, it diminishes the public's confidence in the integrity of the judiciary and their ability to decide cases based on law and evidence. And the Supreme Court recognizes this, and it really came out loud and clear in this Mathesius case. But the point I'm trying to make here is you really need to understand this to kind of underscore the importance that the Supreme Court assigns to ethics instruction. Now, whether they've been successful in doing that, that's an entirely separate question. We're going to be getting into that momentarily.